For legals exclusively. Prepared liquidation, amended Polish law provisions. Bankruptcy Law, Section 7, Prepared liquidation. Article 56A. Application for approval of the terms of sale of the debtor's enterprise. 1. In the course of bankruptcy proceedings, its participant may submit an application for approval of the terms of sale of the debtor's enterprise or of its organized part or of any asset constituent forming a substantial part of an enterprise for the benefit of the acquirer. 2. It is inadmissible to file an application for approval of the terms of sale in respect of asset constituents subject to a registered pledge if the agreement on establishment of a registered pledge stipulates taking over the object of the pledge, or its sale under Article 24 of the Act of the 6th of December 1996 on registered pledge and register of pledges, unless the application is appended with the pledgee's written consent. The provision of Article 330 applies respectively. 2a. The applicant appends the application for approval of the terms of sale with a proof of payment of a security deposit, which is made by the acquirer to the bank account of a court competent to process the application in the amount of 1/10 of the offered price. If the proof of payment of the security deposit fails to be appended with the application for approval of the terms of sale, then the application is not processed. 2b. The applicant appends the application for approval of the terms of sale with a list of securities it is aware of and which have been established by the creditors on the assets covered by the application, together with the addresses of such creditors. The applicant also appends the application for approval of the terms of sale with copies of the application together with appendices for creditors secured on the assets covered by such application. 3. The application for approval of the terms of sale is appended with a description and valuation of the asset constituent covered by the application, drawn up by a person entered on the list of court experts. 4. The application for approval of the terms of sale must contain the terms of sale by indicating at least the price and the acquirer. The terms of sale may be set forth in a submitted draft agreement, which is to be concluded by the bankruptcy trustee. 5. The application for approval of the terms of sale must set forth that the enterprise is to be released to the acquirer on the day of the declaration of bankruptcy of the debtor. In such an event, a proof of payment of the full price into the court's deposit account is appended to said application. 6. The application for approval of the terms of sale may concern more than one acquirer. Article 56AA. Appointment of a temporary court supervisor or compulsory court administrator. 1. In the event the application for approval of the terms of sale is submitted, then the court appoints a temporary court supervisor or compulsory court administrator. 2. A temporary court supervisor or compulsory court administrator files within an indicated time limit a report comprising in particular information concerning the debtor's financial condition, the type and value of its assets, and the predicted costs of bankruptcy proceedings and other liabilities of the bankruptcy estate, which would be met if liquidation proceedings on general principles were conducted, as well as any other information relevant for the processing of the application for the approval of the terms of sale. Article 56a(b). Announcement of submission of application for approval of the terms of sale. The fact of submitting the application for approval of the terms of sale is announced. Article 56b. The valuation price. The sale referred to in this section for the benefit of the subjects indicated in Article 1 to 8 is permitted solely at a price no lower than the valuation price. The valuation price is determined by the court pursuant to the evidence of an expert's opinion. 2. The applicant and the prospective acquirer submit a statement as to whether or not they are in such relations with the debtor as the ones referred to in Article 1 to 8. Article 56c. Granting the application for the approval of the terms of sale. 1. The court grants the application for approval of the terms of sale if the price is higher than the amount obtainable in bankruptcy proceedings through liquidation on general principles, decreased by the costs of such proceedings and other liabilities of the bankruptcy estate which would be incurred in the course of liquidation under such procedure. 2. The court may grant the application to approve the terms of sale if the price approximates the amount obtainable in bankruptcy proceedings through liquidation on general principles, decreased by the costs of proceedings and other liabilities of the bankruptcy estate which would be incurred in the course of liquidation under such procedure, if this is warranted by an important public interest or the possibility to preserve the debtor's enterprise. 3. The court processes the application for the approval of the terms of sale not earlier than 30 days after the announcement on submission of the application for approval of the terms of sale, and not earlier than 14 days after the service of the copies of the application for the approval of the terms of sale on the creditors secured on the assets which are covered by such application, together with appendices and a notice of obligation to present their standpoint within an indicated time limit. Article 56ca. Auction in the event at least 2 applications to approve the terms of sale have been submitted. 1. If at least 2 applications for approval of the terms of sale have been submitted, then an auction is held between their prospective acquirers in order to select the most favorable terms of sale. The provisions of the Polish Civil Code apply respectively to said auction, subject to the following. The terms of the auction are approved by a court with a single judge. 2. The applicants must be notified of the auction at least 2 weeks prior to the hearing scheduled to conduct such auction. 3. The auction is held at an open hearing. 4. The action is held by a temporary court supervisor or compulsory court administrator under the supervision of a court with a single judge. 5. The most advantageous offer is selected by the temporary court supervisor or compulsory court administrator who presents the selected offer in the report referred to in Article 56aa, paragraph 2. 2. If another application for the approval of the terms of sale is submitted, then Article 56AB does not apply.